Good afternoon, everyone. I am our estate planning associate attorney here at the Legacy Legal Team. And today we're going to talk to mainly our clients or future clients who have or are considering a trust of some sort. Today we're going to be talking about the importance of actually funding and properly funding that trust. So you may hear me or any of the other attorneys that have been on here talking about the importance of a trust and how great of a tool they are for estate planning and making sure that what you have goes to whoever you want it to when you pass away and how you want it to. So honestly, it's a great tool. Everybody should have one. It makes sense for your family. But what a lot of people do, they spend all this money, all this time getting this trust set up, and then they stop there. And you would be shocked how many times we have people come into the office and they say, "Oh, yeah, I have a trust." And we're like, "Okay, so what's in your trust? Like, what we would need to make sure that everything's in there." And they're like, "What do you?" So that's just an extra step that a lot of people don't realize that they have to take. At a lot of law firms, you'll get some instructions saying, "Hey, don't forget to fund your trust," and maybe not receive specific instructions about how to do that. Or even if you do, you just say, "Oh, I'll deal with that one day." And then that day never comes. But the thing about a trust is think of it as like a box. The trust is only going to control those things that you put inside of its box. So if you do not fund it by putting those things in, it's simply a piece of paper that has instructions that's never going to apply to anything. And the worst thing is, like I said, you spend all this time, all this money to get this trust done. And then one of the biggest perks of the trust is that you're going to stay out of probate. You don't put things into it. Every single one of those assets is still going to have to go through probate. They'll admit the will, that's a pour over will into your trust. So then you're probating everything to still put it in your trust. So again, time, money, not what anybody wants to do. So like I said, today we're going to talk about the importance of funding it besides that and making sure that you have a good team behind you to talk about the best way to do that and which assets should be going in there. It's really not a difficult process. A lot of people just get very overwhelmed in the process because they say, "Oh my goodness, I have so many things. I don't even know where to start. I don't know what documents to do." Our firm does offer a funding service where we do it for you, but to be completely honest, at least 95% of our clients are perfectly capable of doing it themselves with a little bit of direction. So we always provide you with a sheet of funding instructions that kind of goes through each type of asset you could possibly have and gives you general instructions about how to handle that. So we're going to talk through some of those today, but I'll be mostly talking from an overview of what steps you should be taking, lists to make, the importance of that list, especially for people that come after you, and we'll go from there. I do want to make a little caveat. Of course, work with your attorney on this, but another big thing is making sure you're talking to a tax professional about all of this as well. Sometimes there are tax implications, and since I'm not a tax attorney, I can only advise you so far on that. But for example, we had a big law that changed probably, I don't know, like maybe 4 or 5 years ago. There were big changes about what we could do with retirement accounts. That's one of the really big things that we like you to talk to either a CPA or other tax professional about the implications of transferring those kinds of things into your trust. So it's really good to have a good team behind you. That's your attorney and your tax professional. But really, the first step that everybody should be taking to make sure that the goals of that trust, whether that was just efficiency when you passed away, the cost savings, the privacy, whatever that trust meant for you, you want to make sure that you collect all of your assets by making a list. So when I say all of your assets, I genuinely mean every single asset that you have. So you're going to make a list of your real estate that you have, your vehicles, checkings and savings account, brokerage accounts, investments, qualified retirement accounts like your IRA or 401k, pension plans, every single thing that you have, and like your big personal property items. So if you have expensive jewelry, watches, a piano, like something big like that, make sure you're keeping a list of what that asset is, where it's located. So if it's a bank, make sure you put the bank in the account number. And then if you have any like passwords that are needed to log into those, make sure you're keeping all of that on a list. That's your first step. Figuring out what you have and going through that with your team, determine what needs to go into the trust. The added benefit of this is that when you die, you have hopefully named a successor trustee that's going to step into your shoes to help facilitate all of this and get it to who you want it to go to. they need that list because they may not know what you have. It's not like back in the day when everybody would get like bank statements in the mail. Your personal representative or your trustee would wait for the statements to come in the mail and say, oh, okay, yep, we got their monthly statement from them. So we know there's an account there and it's in the name of the trust. Not really a thing anymore. Really important that you keep that list for funding purposes and for your successor trustee to know what you've got and what they are dealing with. Because a lot of times they have to marshal these assets pretty quickly and notify certain people for certain types of accounts as well. So once you have that first list, you're going to want to go through that with your tax professional and your attorney. Generally, the attorney is going to recommend that everything goes into the trust because we want those trust rules that you have put in place to actually be used. For example, if your trust says, okay, everything gets split between my children 50-50 if you have 2 children, but they don't get anything until they're age 40. If it's not going to go through the trust and instead you have a death beneficiary, like a lot of people when they set up their 401k, they name their children or their spouse immediately as that beneficiary and they never go back and do the step to put it into the trust. They're going to inherit that money outright versus distributed. They're able to take it out immediately. That may not have been what you had in place in your trust. So we'll go through the list. We usually say everything besides vehicle we don't usually put into the trust because especially in Florida, there's just like a form that you can fill out at the DMV and they do it that way. And then sometimes, like I said, there's a big change in the law a few years back about qualified retirement accounts. Sometimes we recommend keeping those out. Sometimes we recommend putting, it's really going to depend on your family situation. Again, if you had rules in place where you don't want people getting money outright, then we're going to recommend it being in the trust for that. That one's kind of a nuanced one that you'll really want to talk through with your team about. But just about everything else, we're going to say, let's put that in the trust so that it follows your rules. As far as personal property, we almost always do an assignment personal property to where all of your property does get assigned to your trust and follows the trust rules, which usually says splits equally between my kids or whomever you've chosen as your beneficiaries. Besides those big ticket items or those really sentimental items that you've already assigned to somebody either in your trust itself or through a personal property memorandum. Great thing about going through this with the team, even if you're the one taking the steps yourself, you have an attorney that's telling you, okay, this is where you need to go. This is the form to fill out. We help you fill that out. If you need an EIN, depending on what type of trust you have, we help you get that. Or we tell them, hey, use your social. And we go that way, usually the way we like to go, but sometimes we can't do that with every trust. And so we help you fill out that form. So again, you're doing it on your own, but not really. It's just you're not having us reach out to the banks ourselves. We just tell you exactly what you need to do and how to do it. And usually we just simply say, go to the bank, tell them, hey, here's my certificate of trust that we've provided for you, and tell them you want to put the account into the name of the trust. Bank accounts sometimes can be a little hairy because banks will have their own rules. Sometimes they won't let you just convert the current account that you have. So then you can either make the trust payable on death to the, make the account payable on death to the trust, or we recommend opening a separate trust account, sometimes depending on what assets and what level of assets you have in that bank account. Again, if we don't have it at least payable upon your death to your trust, it's going to go through probate unless there's a death beneficiary, and it's not going to follow the rules of your trust. So again, going against your main goal, creating that trust. So that kind of leads me into another consideration that some clients have a hard time wrapping their head around, and that's the concept of liquidity. A lot of people, they're saying, okay, well, I put this stuff into my trust name, I'm not going to be able to access it. Not true. For example, real estate. We always want to do that deed for you to put it into the trust to make sure it's done correctly. But that doesn't restrict. Okay, so I'm talking about a revocable trust. That's the most type of trust that I use with people. With a revocable trust, that doesn't limit your ability to do anything with that property. If you're still in your right mind, you still have capacity, you're still able to sell that property, refinance it, do whatever you want on it, just like as if it was in your name individually, assuming that you're the primary beneficiary of your own trust. From there, same thing with bank accounts. The account is in the name of your trust. Typically you're your trustee when you set up your own trust, as long as you're in your right mind and able to do things. And from there, you just sign things as trustee. There's no difference really in the day to day. The benefit of having things in your trust during your lifetime and not just payable upon death is that if you do become incapacitated, again, you have a successor named for when you're not able to control your own assets. You have a successor named, they step in your shoes, they can immediately access that account and use it for your benefit according to the rules of your trust. So, for example, usually in our trusts, we say, I prefer to stay at home for as long as possible. So, we've given some direction that you don't want to go to a facility. So, now your successor trustee is able to step in and immediately access your accounts and use those to pay for in-home healthcare, as an example. So like I said, some people have this weird concept of saying, if I put it in my trust, not liquid, I can't access it. I don't want to make tidy things up. For those people that like to have control and are worried about it, sometimes we say, okay, you know what? Let's put all your big accounts in there. Let's put your savings account. Let's put your investment accounts. But we can keep out what we consider like an operating account. So that's the one that your paycheck's going into, you're paying your bills out of, and you only keep a couple $1,000 plus or minus in there every month. Your savings is separate and investments are separate, all of that stuff. So sometimes we're okay with that as long as we remember it's either make that payable on death to your trust or to like a child or whoever's going to be handling like your funeral expenses and stuff like that, because then they can usually access that more readily to use that money for those types of things. Obviously, during this whole process, things change. You get new properties, move, you downsize, you get new money, you get new accounts, a new investment account at Edward Jones or wherever you're working. So what we usually say is every year, sit down with your list that you have created that's with all your copies at home and say, okay, what have we done this year? What do we need to add to this list? And then you say, oh my goodness, we opened this account and we completely forgot to do something with that when we were opening it. You go through the process again. You take the certificate of trust and say, oh, yep, we forgot to tell you about this. But ideally, anytime you're getting a new asset from the get-go, you're dealing with it, especially real estate, because again, why would you want to do a deed at closing that goes to you or you and your spouse, and then you realize a year later, oh, we didn't put that in our trust. We probably should do that. Now you're paying for another deed that goes from you individually to your trust. So you can do it from the get-go, or we can do it after the fact. It's not a big deal. It's just going to cost you a little bit extra money. Like I said, important to keep that list updated, for funding purposes and also for your successor trustees purposes. And then obviously on top of that, review your trust every few years, the trust itself, not the assets that are owned by it, but your trust itself, because things change. Asset levels change, finances change, family dynamics change. You might have a new grandchild that you want to do something for now, and laws change. So we haven't had any huge updates in this type of law, but we do have some big changes probably coming up next year as far as tax law is concerned. Of course, we could tell the future, but it's looking that way. Another big reason to be keeping an eye on things and your asset levels, because that may mean that we need to make some changes to your trust or do some additional planning measures that we didn't do when we first did your trust. That's pretty much all I had today. Super important, obviously, to fund your trust, properly fund it, fully fund it, do everything that you need to, because without doing so, those assets stay out of the trust, have to be probated, and don't follow the rules of your trust unless we have a pour-over will, which again, we still have to go through probate, spend all that money to put it in the trust when we could have just done it from now, but it's not that difficult. So I have a question here. Can you explain the legal process of transferring ownership of assets into my trust? So it's going to depend on the type of asset. For example, real estate. We just do a new deed. It's called a trustee deed. And it says it's going from Heather Ward individually to Heather Ward as trustee of the Heather Ward Living Trust. And then you just sign that. It goes into the trust. And again, really ignored for all purposes, like tax purposes, all that. Still you, but it follows those trust rules. For bank accounts, usually what you do is you go down to the bank, say, hey, I want to transfer this account into the name of my trust. Here is my certificate of trust that my attorney prepared for me, which is basically a shorthand version of your trust that says all the important things that they need to know, but none of their business about who it's going to when you die. And then they either set up that account for you or they make you open a new account, depending on the bank's rule. It all depends. For the same for checking, savings, investment, brokerage, all of those things are usually pretty similar. Those are the biggest assets that we see people dealing with. Again, we don't usually like to put vehicles, boats, those kinds of things in there. But if you have like a collectible car, 60 sports car that you've redone, or like $100,000 for a car, something like that, we might have a different conversation. But for most people, not worried about putting those in there. Question again, are there any assets that wouldn't make sense to put into my revocable trust? And that's a hard question to answer because it's really going to depend on your situation, what types of assets you have, and what rules your trust itself contain. Sometimes you don't necessarily need to put things into trust if it's going to have the same result. But again, we like to have it in there because the trust has backups. So, for example, a lot of people, when they have a really simple estate plan, they say, I have 2 kids. They're not going to fight about anything. They're old enough. I trust them. They can get everything out right when I die. So we tell them, okay, you could name it payable on death beneficiary on that account. And then once you pass away, all they have to do is take your death certificate and they will write checks to those people. What we can do with a trust that we can't do with that, which would be the alternative, is do the but if. But if my son dies, I want his share to go to his kids. We can't usually do that with death beneficiaries on accounts. So that is why we like it to go into trust. Again, for some people, it makes sense to keep a few assets out if you didn't have any restrictions included in your trust for that particular asset. But just about anything besides vehicles, boats, those kinds of things. And then sometimes we recommend keeping qualified retirement accounts out of trust, just depending on your situation and the type of beneficiary that you have, because there are exemptions to the rule that have to do with disabled beneficiaries, your spouse, like they have better tax consequences, leaving it to them out of trust versus in trust, depending on your trust terms. So again, it just really depends on you and your situation. Just wait a couple more minutes to see if there's any more questions. It's hard to do something on this other than to explain, hey, it's really important to do this because it is such a nuanced thing depending on your situation and what assets you have. Right. So that looks like that might be it for today. Again, my name's Heather. I'm really happy if any of y'all joined me today. And if not, if you are watching it on the replay afterwards, thanks for joining in. If you have any questions about anything that I talked about today or anything about estate planning in general, I'd be really happy to talk to you. You can give us a call at the office at 352-394-7408. And I hope to speak with some of y'all soon. Hope you have a great day and a happy first day of summer again. Bye.